the hearing of the appeals, Belhaj and Rahmatullah.
My Lords, Lady, yesterday I'd made the point that every domestic court that has considered a plea of state immunity in circumstances materially similar to ours has concluded that there's no bar to the court reaching findings about the legality of a state's conduct, provided that the proceedings don't affect the legal interests of that state. The only cases in which a state has been held to be indirectly impleaded are those in which property that it owns or controls is the subject matter of the proceedings. The ILC's commentary, as I showed yesterday, confirms that these property cases were the only ones that the ILC had in mind when drafting Article 6.2b of the UN Convention as a reflection of current state practice. And that is, no doubt, why the respondents have tried to bolster their argument by reference to the monetary gold principle, which is what I need to turn to now.
Do you mean the respondents?
I'm sorry, I mean the appellants.
It's easy to forget.
Yes, Ladyship's quite right.
Is there any principal reason why property should be a special case?
Well, what the cases show is that those property cases are the only ones in which the necessary closeness is established between the proceedings and the relevant effect on rights.
Yes, I see.
So, if I can put it like that, there isn't an in-principle reason why property should be a special case. Okay. But it is striking that the only cases are property cases, and that perhaps indicates something about what is meant by affect in the relevant jurisprudence.
Thank you.
Well, I suppose that the only way you can hit someone is either in their person or in their property, is it? Unless,
exactly, my Lord, yes.
At least perhaps that's not right. You can hurt them in their feelings, but...
Well, that's their person, in a way.
Yes. Well, when your Lordship mentions hurting them in their feelings, and that is precisely the kind of effect which we say is not encompassed by the principle.
Insulting
not,
state dignity.
As it was put earlier, I think, by Lord Sumption in argument, this is not an immunity against embarrassment. It is not a question of affecting political interests or moral interests. It is a question of affecting legal interests of the state.
That's a slightly different point. I understand that. Yep, okay.
Monetary gold.
Yep.
First point is that both the Court of Appeal in Belhaj, see it paragraph 42, MS 351, and Mr. Justice Leggett in Rahmatullah, see paragraph 78, MS 977, regarded the monetary gold principle as applicable only to the jurisdiction of international tribunals. And they were influenced, no doubt, by the fact that there is no case in which the principle has been applied by a domestic court in the context of state immunity jurisprudence. If the appellants want to rely on the monetary gold principle as a principle applicable to national courts, they would have to show some state practice applying it in that context, and there is none. But I recognise that that is not a very intellectually satisfying answer to the question posed by Lord Hughes yesterday, which is, well, why in principle should the doctrine which one sees in the monetary gold line of cases apply to international tribunals only and not to domestic tribunals? And I want to try and answer that question.
Right.
We say, my Lord, that the answer lies in the different consequences of a judgment of the ICJ as distinct from the consequences that attach to the judgment of a national court. And to make that point good, I'll just ask your Lordships and your Ladyship to take up bundle 19, tab 142, MS 8106. This is the UN Charter. Yep. Now, Article 92 of the UN Charter provides that the ICJ is the principal judicial organ of the UN. Article 94 tells us what the effect is of a decision of the ICJ on parties to that decision. By that article, every state that is party to proceedings in the ICJ must comply with the decision. So pausing there, any failure to comply is a breach of the UN Charter, and by Article 94.2, such a failure has potentially serious consequences. It can be referred to the Security Council. So as a matter of principle, when the ICJ gives a decision which involves a finding of illegality in respect of a third-party state, the consequences often go well beyond mere embarrassment to that third-party state. Why? Because there are at least two other states which are obliged as a matter of international law to comply with the decision. And those two states are not just any two states, they are two states whose dispute inter se depends in a crucial respect on a determination of the rights and obligations of the third-party state. It follows that a decision of the ICJ that is binding on the state's party to it, but that purports to determine another state's rights or obligations in international law, is unlikely to be truly capable of being described as res inter alios acta, in the way that a determination of a national court could attract that description. Now, the East Timor...
so?
Well, I'd perhaps answer your Lordship's question by reference to an example, the example that was relied on, the East Timor case. And just so your Lordships have it, it's in bundle 16, tab 110, MS 7050. And I just want to show your Lordships and your Ladyship what was actually at issue in that case.
Right. Yep.
If one takes up the judgment at 7050,
Yep.
paragraph 25,
Yep.
one can see what Portugal was arguing for in that case.
Yes.
It was arguing that by entering into a treaty with Indonesia, Australia had violated its obligation to treat Portugal as the only power capable of making treaties in respect of East Timor.
Yes.
And one sees that from paragraph 27 as well. Now, if the ICJ had entertained that point and found in favour of Portugal, it's of course right to say, as was pointed out in argument, that Indonesia, not being party to the proceedings, would not have been bound. But Australia would have been bound, and bound by a judgment finding that it had no business as a matter of international law entering into any treaty with Indonesia on this subject. Australia would then have come under an obligation under Article 94 of the UN Charter to comply with that judgment. That would have had an effect on Indonesia's legal rights and interests, because the counterparty to the treaty that it had entered into would be bound to regard the treaty as invalid. And that is totally consistent, we say, with what the court actually said in the East Timor case at paragraph 34,
Which we looked at earlier, yes.
which your Lordships and your Ladyship have already seen.
So
The reason
Indonesia
why
would have been
judgment-
affected as a result of this, albeit indirectly. That's your point.
That's exactly the point.
Yes.
And if one looks at the language of 34, it's consistent with it, because the reason why a judgment would have, why the judgment would, in view of the court, have as its very subject matter Indonesia's rights and obligations, is that it would amount to a determination that Indonesia's entry into and presence in East Timor are unlawful, and that as a consequence, it does not have the treaty-making power in matters relating to the continental shelf. In other words, it would be impugning, so far as the counterparty Australia is concerned, the ability of Indonesia to enter into bilateral relations in respect of that subject matter with it. And we say, my lords, my lady, that exactly the same analysis applies to the decision of the arbitration tribunal in Larson and the Hawaiian Kingdom. I'm not going to ask your lordship's ladyship to turn it up, but I'll just give you the reference.
Yes.
One can see at MS 11097 what the claimant was asking for in that case. The claimant was, your lordship's ladyship may think somewhat ambitiously,
Yes.
asking to force the hand of the respondent, the Hawaiian Kingdom, to intervene or otherwise act to successfully end the occupation of the Hawaiian Islands. Now,
Well, it was a collusive action, wasn't it?
first of all, it was a collusive action, so it wasn't a real dispute, as the arbitration tribunal found. But if, just leaving that point aside for a moment and just supposing there'd been a real dispute, if the claimant had been successful, the result would have been an award binding on this entity, the Hawaiian Kingdom, entitling it, or indeed requiring it as a matter of international law, to resist the occupation, so-called occupation, by the United States. Now, it's not very difficult to see, in my respectful submission, why that could be said to affect the legal rights of the US. It would be a direct encouragement, or indeed a judgment, saying that the Hawaiian Kingdom was required to initiate some kind of insurrection against United States rule. Now,
I mean,
a judgment...
these cases are rather similar to, aren't they, though, to Dolphus Meag?
Well, they come from the same principle, which is, in its essence, a principle about property. And Dolphus Meag is an in rem case.
Yes,
so was monetary gold.
Yeah.
And the point I'm trying to make here is that it is much easier to see how the direct kind of connection required between the proceedings and the effect on legal interests arises in the ICJ context or in the context of proceedings in some other international tribunal than it is to see how it would arise in a national court.
Well, it's in Dolphus Meag. They said either the result would be to order the Bank of England to hand over the gold to Dolphus Meag, in which case the French, British and whatever the other government was, the Commission anyway, would find itself having to sue Dolphus Meag rather than its Bailey Bank. Or alternatively, if damages were awarded, then the bank would acquire property and the Commission would suddenly find itself at odds with its Bailey.
Yes. The point is that these cases are not authority for the proposition that some looser connection will do.
Yes.
They are...
No, I'm simply... It's a point in your favour, actually.
Yes, indeed. So, my lords, my lady, a domestic court, by contrast, cannot affect third-party states in the same way. Why? Because nothing the domestic court says will have any effect, legal effect, that is to say, direct or indirect, on the foreign state, its property or activities, nor will the domestic court's judgment create obligations in international law for any state. First of all, most domestic court judgments are given in proceedings that are backward-looking, in the sense that their aim is to determine whether rights have been breached and provide a domestic law remedy if they have.
Yep.
But even where proceedings are forward-looking, and even where the defendant is a government, such as this case, of course, this case is backward-looking, but the defendant is a government, the established rules of non-justiciability mean that the court will not purport to interfere with the state's treaty-making powers or its conduct of foreign relations generally, as Mr. Hermer said yesterday.
What about the point that if the British government in this case was found liable for damages, they could look for a contribution to another government?
Well, my lord, perhaps they could, subject to the established rules of...
Why isn't that isn't that an effect,
well,
legal effect?
It's not an effect because of the rules of state immunity.
Right. That's what I thought.
So,
that's what I thought you'd say.
The rules of state immunity provide the answer to the question.
Well,
because the United States is at no stage going to be subject to any direct legal effect, unless, of course, it consents. If it consents, then the principle on which my learned friend relies, the principle of sovereign equality of states, isn't violated anyway. But if one is looking at a forward-looking case, even where one's looking at a forward-looking case, for example, a judicial review case or a habeas case, the courts will not purport to interfere with the state's treaty-making powers or conduct of foreign affairs.
I suppose you would say that the Rahmatullah number 1 is an example.
It's exactly the point I was coming to. It's an example of that. So if your lordships look at Rahmatullah, it's at paragraph 60 and 68 of Rahmatullah number 1, Authorities Bundle 1, tab 4, MS 1678 and 1680. That is a very good example in Lord Kerr's judgment, with which the other members of the court agreed on this particular aspect, of the court taking very great care to ensure that the forward-looking relief that
Yeah.
it gives does not trespass on those established non-justiciable areas, as
30.
Mr. Herm said.
Which paragraph?
60
I'm
and
sorry,
68.
60 and 68.
Yes, you ought to have an eye on the time.
Yes, I am.
We came in a little bit late, so you've got a minute or two.
My lords, my lady, if the non-justiciability principle doesn't apply, as in Rahmatullah, that's because the case is concerned solely with the domestic law rights and obligations of the parties, as is this case.
Yep.
In conclusion, we say that the monetary gold cases are consistent with a narrow reading of what affects a third party's legal interests, and in any event, the structure of the international law system explains why any decision of the ICJ or an international tribunal capable of finding states as a matter of international law is likely, much more likely than a national court decision to affect a third state's legal interests in this narrow sense. Now, can I just make this one point about the interrelation between act of state and state immunity? We say that any analysis of the correct relationship between the two starts from an assessment of how international law requires states to give effect to the principle of the sovereign equality of states in the context of civil disputes in their municipal courts. And the answer is supplied, and exhaustively supplied, we say, by the rules of state immunity. Those are a condensation of state practice, and if the case is not barred by state immunity, then it follows that the adjudication of the issues in the case doesn't offend any of the rules that states have agreed are required to maintain their sovereign equality. I just want to show your lordships one foreign text to make this point good. It's in Bundle 23.
Thank you.
And it's a French textbook by Caro and Morella. Now, we've translated the relevant part at paragraph 41 of our case. Bundle 23, tab 191, MS 9488. The relevant... We've translated the relevant paragraph, which is paragraph 25, as I say, at paragraph 41 of our case. It's our own translation, I'm afraid.
Which page is it?
9488, MS 9488, internal 701.
Yep.
But just looking above the paragraph that we translated,
Yes.
one can see no rule of positive international law precludes a national judge from assessing the conformity of an act of a foreign state with respect to international law. One couldn't get a clearer statement than that, and there is a very similar statement by Professor Weil in Authorities Bundle 25, tab 207, MS 10262, drawing on, amongst other things, the views of...
10262.
Sorry?
Tab?
I'm sorry.
Bundle 25.
25, tab 207, MS 10262.
Yeah.
Drawing on the views of Dr. Mann, which also sees the act of state doctrine as reflecting US constitutional concerns. Now,
Marked up, thank you. Yep.
my lords, my lady, the very simple point we make, and it really bolsters an observation that you've already been shown by Mr. Justice Leggett in the Rahmatullah case, is that if this is how a French court would understand the obligations on it as a matter of international law, then it's very difficult to see why a common law principle of abstention can properly be based on considerations of sovereign equality. That is not to say that there's no principle of non-justiciability going beyond the contours of state immunity, just that it cannot be underpinned by sovereign equality.
Right.
The starkness, we would say, of the French understanding of this issue justifies Mr. Justice Leggett's observation that the adoption of such a general principle would be redolent of inferiority and subordination, not equality. Now, I was going to say something about Noor Khan, but I think my time is up. Perhaps I can just give you one sentence about it. It's a case about discretion. One sees that both from the Divisional Court and the Court of Appeal, in particular Lord Dyson's judgment at 21.
Can you give us the page number?
I will. It is...
If you haven't got it immediately to hand, we'll find it. Don't worry.
I'll find it.
No, don't worry. That's fine. Paragraph 21.
The beginning of that judgment is 2326.
That's very helpful. Thank you very much.
Second point, neither the territoriality exception nor the public policy exception were relied in that case. Sometimes, my lords, my lady, one can draw something from the fact that a particular point wasn't taken by counsel, but since the counsel in question was me, I'm afraid there's rather limited weight that my learned friend can get from it. Unless I can assist further, my lords, my lady, those are my submissions.
It's very helpful, Mr. Chamberlain. Thank you very much indeed. Ms. Jones. Ms. Leaven.
My lords, my lady, we appear on behalf of the UN rapporteurs on torture and on the working group on arbitrary detention. And the focus of our submissions is on the requirements in international law on the prohibition against torture and enforced disappearances, secret incommunicado detention. Just in terms of introduction, where that fits into the arguments that the court's been hearing is that, as Mr. Chamberlain has just been going through, foreign act of state is a purely common law doctrine, not itself part of international law, and not claimed by the appellants to be so, and it should therefore in our submission be defined or limited by reference to international law obligations to provide civil redress for allegations of both torture and what I'm going to summarise as enforced disappearance. My oral submissions are going to cover three topics, albeit in increasingly short order. First of all, the prohibition against torture and the terms of the Convention Against Torture. Secondly, the prohibition against enforced disappearances. And thirdly, and extremely briefly, to show you the one international document on the meaning and scope of sovereign equality. Turning then to torture, self-evidently, my lords, my lady, by reason of the shortness of time, I need to make extensive reference both to our case, our written case, which is in Core Volume 1, Tab 10, MS 275, and to the appellant's response, which is to both our case and Mr. Chamberlain's case, which is at the end of Core Volume 1, MS 11484. In terms of the international prohibition on torture, the starting point is that there is no dispute that the prohibition against torture is jus cogens. That is not disputed by the appellants, but it is worth stressing the fundamental and unequivocal nature of that prohibition. You can't, I suspect, get any higher prohibition in international law. And if I can just refer the court, without going to it, to the speech of Lord Bingham in A number 2, which we set out the relevant paragraphs at paragraph 22 of our case, page, as I've said, 275 in the MS documents. But can I then go to the, as it were, the new point, the point that the court hasn't looked at, which is the terms of UNCAT itself. UNCAT, the convention, is found at volume 18, tab 133, MS 7758. And if I can ask the court to turn that up, because the precise terms are extremely important, particularly in some ways to the response to the appellant's response. Article 1, the court looked at very briefly yesterday during Ms. Kaufman's submissions, but the detailed terms of it for this case are absolutely crucial, MS 7759. Because for the purposes of the Convention, Article 1, the term torture means any act, and then we start off with what one would obviously, in ordinary words, expect, which is intentionally inflicted physical or mental harm. But then, 6 lines down, when such pain or suffering is inflicted by or at the instigation of or with the consent or acquiescence of a public official or other person acting in an official capacity. And that is absolutely critical because torture, the act of torture within Article 1 of this convention, includes the acts of consent and acquiescence by somebody who has no direct physical responsibility.
Yep.
So to put it within the facts of these cases, Article 1 covers the person who isn't in the room when the torture occurs, isn't in the prison, isn't necessarily in the country. All of that falls within Article 1. And it includes, therefore, the act of the official of a state where the state consents to another state's physical act of torture, or where multiple states conspire together and each consent. That all falls within Article 1, and that's critical to understand how the prohibition works. And in real terms, of course, that means it doesn't just catch the individual security officer, it goes all the way up the tree, which is absolutely critical to the nature of the prohibition. And so in terms of the allegations here about the appellant's involvement in torture, that involvement falls within the primary definition. We'll look in a moment at aiding and abetting and the International Law Commission position, but this isn't a case on the respondent's pleaded case where the appellants fall within what we would consider to be aiding or abetting or being an accessory. They fall within the primary definition. And the appellant's argument on UNCAT seems to be, we analyse it down as being 2 points. First of all, that UNCAT does not require universal civil jurisdiction to be imposed by states. And that's the appellant's response, paragraph 97 onwards. And secondly, that the facts of this case are a complicity case, and therefore one should look at Article 16 of the International Law Commission draft 2001 articles. Those appear to be the 2 primary points taken against our argument. So the first one, the jurisdictional reach of this convention. If the court turns on to Article 14 of the convention, each state party shall ensure in its legal system that the victim of an act of torture obtains redress and has an enforceable right to fair and adequate compensation. Self-evidently, as a matter of construction, the act of torture referred to there is the act of torture within Article 1. And it's our submission that we don't go so far, and I should make this entirely clear, we don't go so far as the respondents and Ms. Kaufman yesterday afternoon. We do not argue that there is universal jurisdiction required under Article 14. Our argument is that the jurisdiction extends in a wholly conventional international law manner to the state's own citizens. So there's a territorial jurisdiction, but there's also an individual jurisdiction in respect of the state's own citizens. So here, all the appellants are beyond doubt citizens of the United Kingdom. Yeah. And therefore, Article 14 requires redress against the appellants. It may also be relevant, but it is, I would accept, quite difficult to see how this fits in, that as far as the acts of the appellants are concerned, there's no suggestion they didn't take place within the UK. But I appreciate that that's quite complicated as to quite understand what the implications of that point are. But just in terms of universality in respect of your own citizens, the first point is that this convention makes an absolutely clear distinction between those obligations that only apply within the territorial jurisdiction of the state and those that don't. So if the court looks quickly, because of the shortage of time, Article 2.1, each state shall take effective legislative, administrative, judicial measures to prevent acts of torture in any territory under its jurisdiction. So we've got a territorial limitation there. Similarly in Articles 11 through 13, and similarly in Article 16. And in terms of the structure of the convention and the purpose, that makes perfectly good sense, because those are what I would describe as proactive duties on the state that only make sense within your own state. So that's point one about jurisdiction. The second point is, and I'm afraid this is one of the ones where we've got two new documents. We kept it to two, and this is one of them. It is perfectly orthodox in international law that the state's jurisdiction extends over its own citizens, even where the act takes place outside the state. And to make good that proposition to the degree I need to, We've handed up one page from Brownlee. Well, actually, I think it might have grown into more than one page, but you only really need...
You're relying on one page.
Relying on one page.
Thank you.
It should be, and it's page 459.
Thank you.
And you'll see at 457, it's under a heading of prescriptive jurisdiction over crimes, and 459, the second heading for basis of jurisdiction. The first is territorial, the second is the nationality. Nationality as a mark of allegiance and an act of sovereignty is also generally recognised as a basis for jurisdiction over extraterritorial acts. I won't read the rest. I don't think that proposition is controversial in public international law. It may be controversial to the appellants in this case, but seems to be well understood more generally. And then if we go back to the convention itself, that orthodox concept is reflected quite clearly in this convention in Article 5. MS 7760. Each state party shall take such measures as may be necessary to establish its jurisdiction over the offences referred to in Article 4 in the following cases. A, when the offences are committed in the territory. B, when the alleged offender is a national of that state. C, when the victim is a national of that state, if that state considers it appropriate. So in terms of victim, there is a discretion. But in terms of offender, and of course here we would be talking about offenders, there is no discretion. The jurisdiction on offences has to extend to nationals of the state. And that, in our submission, is a simple reflection of the orthodoxy referred to in that passage from Brownlee. And in support of this analysis, can I plead one other, hopefully helpful authority, speech, that of my Lord Justice Mance in Jones in the Court of Appeal. Volume 27, tab 217, MS 10778.
Yep.
Of course, the facts of Jones were that the defendants were, or the defendant, apart from the state, the individual, was a Saudi citizen. The events had occurred in Saudi Arabia and the individual was a Saudi citizen. So it is critically factually different from this case. And my Lord Justice Mance, as he then was, at paragraphs 20 to 21, which is MS 10796, 20 to 21. I'm not going to read it through, but it precisely reflects the argument that I have just put. It relies on the distinction I've just made between Articles 5.1b in the Convention and 5.1c, and it's clear from the end of paragraph 20 that if the facts, I say it's clear, it was difficult to say that where the judge in question is in the court, but my reading of the end of paragraph 20 is if the facts had been the facts as in these cases, my Lord would have supported the argument. It's because it's the critical distinction that the defendant there was not a UK citizen. End of paragraph 20.
Thank you.
Can I then turn...
That distinction made in the analysis in the House of Lords.
The House of Lords didn't deal with it because, of course, the House of Lords didn't need to deal with it. It wasn't the facts. No. And so I'm not going to go back through this, but when the passage of Lord Bingham, which my learned friends rely on so heavily, Lord Bingham was dealing with the facts of a Saudi citizen in Saudi Arabia. And there's no suggestion that he was intending to think about anything else at all.
There's nothing you say, they just didn't get to this point.
They didn't get to this point.
Absolutely.
No.
So you say the reasoning of Jones in the House of Lords has no bearing on what we have to decide, do you?
Absolutely.
Certainly not on this point.
Not on this point, my lord, no. It's plainly obiter, there can't be any question about that. And it doesn't seek to determine this point.
No.
And there isn't even any obiter comment on this point. There's the general comment of Lord Bingham, but in my submission, once one goes back to the Court of Appeal, it's perfectly clear that Lord Bingham just wasn't thinking about this point, and why should he?
Yep. Okay.
So can I then turn to the appellant's other response point about complicity?
Yes.
Now, we say, taking up the convention again...
You say we don't get there?
We say we don't get there, my lord. We don't need to look at the ILC draft articles on responsibility, reference, volume 17, tab 127, MS 7533, because the appellants here fall into direct responsibility under Article 1 of UNCAT. We say, to the degree that we need to, that the appellant's reliance on Article 4 of UNCAT is misconceived because Article 4 doesn't seek to change the definition of Article 1, save that it broadens it, or potentially broadens it, in respect of subsequent attempts to cover up. Article 4 would cover a subsequent cover-up. Complicity would include that, whereas Article 1 wouldn't. But we reject any suggestion that Article 4 is narrowing the scope of Article 1. It goes a bit further than that, and I'm going to take this quickly because of the time. If there is any need to look at the ILC document at all, then the appropriate article isn't Article 16, as the appellants suggest. It's Article 47, MS 7543, which covers plurality of responsible states, where several states are responsible for the same international...
Sorry, what was the reference?
7543.
7543, my lord, volume 17, tab 127.
Yep, and you're relying on Article
47, plurality of responsible states. Where several states are responsible for the same internationally wrongful act, responsibility of each state may be invoked in relation to that act.
Yes, I see.
All of this matters because the appellants rely on Article 16.
Yep.
They say that's the governing or the relevant provision, 7537. And the reason they do that is that Article 16 says, a state which aids or assists another state in the commission of an internationally wrongful act by the latter is internationally responsible for doing so if that state does so with knowledge of the circumstances of the internationally wrongful act. So that's why the appellants want to take you down this line, because they want to say you've got to prove knowledge and there's not enough evidence to prove knowledge. So we say, one, you never get to these things. Two, if you do, you get to Article 47. But three, and in any event, even if you get to Article 16, knowledge of the circumstances of the internationally wrongful act, where the internationally wrongful act includes participation or consent, plainly doesn't mean actual knowledge in the sense that you've got to stand over the man being tortured. It plainly can extend to the facts pleaded in this case. And I'm not going to take you back to the facts, but the best way to find it is the Belhaj particulars of claim, paragraphs 59 and 61, which is in the appendix, part 1, tab 11, MS 526. So we say whatever route you go down, you still end up with falling within the prohibition of torture under this convention. Second issue to cover, enforced disappearances and secret incommunicado detention. We say that is a separate violation of fundamental norms of international law. And, my lords, I'm just going to refer your lordships, your ladyship, to our case at paragraph 33 onwards, where we set out the various charters and cases which are relevant. But can I just take you to the convention, the Enforced Disappearance Convention, which is at volume 17, tab 121, MS 7484, because I just want to show the court the breadth of the definition. So there's no question here as to what's covered. Article 2, page 7485, for the purpose of this convention, enforced disappearance is considered to be the arrest, detention, abduction, or any other form of deprivation of liberty by agents of the state or by persons or groups acting with the authorisation, support, or acquiescence of the state, followed by a refusal to acknowledge the deprivation of liberty or by the concealment of the fate or whereabouts of the disappeared person, which place such person outside the protection of the law. So although it's called enforced disappearances, it covers secret incommunicado detention.
Thank you.
And it is important to emphasise that to fall within Article 2, it's not just an Article 5 ECHR case. It goes way beyond that to fall within Article 2, but also, if one thinks about the facts of these cases, Mr. Rahmatullah's case, who obviously I'm more familiar with, 10 years in secret incommunicado detention in appalling conditions with no access to lawyers or the outside world. So it would be wrong to just consider these cases as being analogous to Article 5 of the ECHR. And that's important because the test that the court is applying here as to when the public interest, public policy exception should apply within foreign act of state doctrine is the test set out in UKOS at paragraph 69, is the allegation one of grave infringement of human rights. And in my submission, there can be no possible question that the facts of these cases amount to allegations of grave infringement of human rights. The appellants try to draw a distinction between the torture aspect and the enforced disappearances aspect, but in my submission, that simply doesn't stack up on the issues. And just to finish off on that point, it may be put to you by Mr. Eady that the UK hasn't signed this convention. So it is important to understand why they haven't signed this convention. And the way to find that, it's been signed by 94 states, has entered into force, and the UK's position is set out at volume 9, tab 78, and page, I'm sorry, my lady, 4697. This is a note done by the House of Commons Library in respect of the international the forced disappearance. And if
this
you go to
UK position,
4697 UK position, to quote, the government support the international convention, believe it will have an important role in preventing enforced disappearance and secret detention. The reason they haven't signed it is about, well, according to this, how they transpose it international law.
Sorry, say that again.
How it's transposed into national law, my lord.
Strange.
Well, 4697 at the top, my lord, there's a quote.
Yes, I see that.
Yes. The UK only signs a treaty once it's confident it can properly implement it and once any necessary changes to legislation have been made so that domestic law is compatible with the treaty.
Okay, well, that's the explanation.
That's the explanation given, my
Okay.
lord. Not
Thank
for me
you.
to take it further.
Nope, understand.
And we, of course, say that the convention reflects customary international law, but critically for UKOS, it plainly reflects a grave infringement of human rights.
Understand.
So the last thing on a slightly different topic I need to cover is the question of what sovereign equality means. Because my learned friend, Mr. Eady, as I understand the case, argues that the rationale behind foreign acts of state, as well as state immunity, is one of protecting sovereign equality. So we thought it would be useful for the court to see what appears to be the only statement in international law or signed by international bodies as to what sovereign equality encompasses. That's the second document. I've found it up. And this...
Yeah, what's it look like?
It's headed Resolutions Adopted on the Reports of the Sixth Committee.
Yeah, I see. Thank you. Got it. Yep. And where do you want us to look in this?
So can I just explain what it is very briefly first?
Good idea, yes.
This is the Declaration on Principles of International Law concerning friendly relations and cooperation in accordance with the Charter of the UN. And it's perhaps relevant to note, on the first page, on the left, second bit of the preamble, having considered the report of the Special Committee on Principles of International Law. So This has got a international law basis.
Thank you.
And if you go to the last page, on the left-hand column at the bottom, there's a side heading, the principle of sovereign equality of states.
Yes.
All states enjoy sovereign equality, they have equal rights and duties and are equal members of the international community, notwithstanding differences of an economic, social, political or other nature. In particular, sovereign equality includes the following elements. States are juridically equal. Each state enjoys the rights inherent in full sovereignty. Each state has the duty to respect the personality of other states. All of that is reflected in state immunity. Territorial integrity, political independence. E, I don't think has any relevance. And then F, each state has the duty to comply fully and in good faith with its international obligations and to live in peace with other states. So, subject to the principles of state immunity, there is no suggestion that some other principle comes in of sovereign equality which trumps international obligations.
Are you saying, because we've seen references to this, that if a state acts contrary to fundamental norms, it can't be a sovereign act, Miss Leaven? My lord, subject to the... It could be a sovereign act, but it would be knocked out by state immunity, as I understand it. It's not that international law trumps state immunity. There's a balance to be struck, and the balance signed up to is reflected in these principles.
I think in the Warfare case we were looking at just before the adjournment yesterday, the American judge put it on the basis, if it's contrary to international law, norms, it can't be a sovereign act, and I wondered whether that was accepted.
I'm not sure... No, I'm not sure that's right, my lord. That's not my understanding of the way that state immunity conceptually works. It's still a sovereign act, but it's not a one that can be sued upon in the domestic court because of the principle of state immunity.
Anyway, the UK Act starts with a principle of general immunity and then creates a large number of exceptions, so it proceeds the other way around. It's rather difficult to accommodate that notion into the way the Act is drafted.
Yeah, so certainly what your Lordship said accords with my understanding.
This obviously says what sovereign equality includes. It's not really focusing on the domestic court position, is it?
Quite.
No, my lord. We put it before the court because it seemed to us to be the only international document which cast light on this, and because of F, which is a plain acceptance that sovereign equality encompasses obligations under international law. It doesn't seek to carve out other exceptions. That isn't the function of this document.
In a sense, A to E is the benefit and F is the price.
Yes.
Yep.
Or the way I put it would be the balance.
All right.
Yes, but I mean, F is the price owed to another state. It's not owed to its citizens or enforceable in the other state's courts.
No, that I think is right, my lord, but it's the deal between states
Why should the state, if you say, if State A is entered into that obligation with State B, why should State B prevent its courts from investigating a breach?
Absolutely.
Yep.
My Lords, my Lady, there is, of course, far more detail in our case, but I'm
yes.
conscious of keeping, I think, to my time, unless there's anything else I can assist the Court with.
Well, thank you very much indeed, Ms. Stephen. Thank you. Mr. Sybil.
There's a quick change of personnel, if not furniture.
Take your time, don't worry. Fine. Yes,
It took about an hour to open this part of the appeal, and I shall be, I hope, correspondingly brief in reply.
Thank you.
Well, may I start by dealing with Lord Wilson's question about sovereignty and international norms. The answer to that, my Lord, apart from the State Immunity Act, is Jones itself, in which the issue was specifically addressed. And, of course, it's the jurisdictional immunities case, the Germany and Italy case, in which it's impossible to conceive of more serious allegations, war crimes, crimes against humanity. They didn't in any way alter the nature or character of the acts, which remained sovereign acts. So, my Lord, moving from that to the indirect impleading cases, you'll remember that the parties take various positions. The Court of Appeal in Belhaj recognised two categories of indirect impleading cases, the pre-statute property cases and Jones. That's 35 and 36 of their judgment at MS 348, 349. The respondents and the interveners submit that there's only one type, the property cases, and they argue, founding themselves on Mr. Justice Leggett, and contrary in this respect to the decision of the Court of Appeal, that Jones was a direct impleading case, and you have my submissions on that. But Lord, in oral argument, it seemed, at least to us, that learned friend Miss Kaufmann was disposed to accept that when one considered those domestic cases, it was at least possible to analyse them as establishing indirect impleading beyond property cases. And may I just remind you of the passage that she was looking at when she made that observation. It's in Bundle 8, and it's the case of Rahmatullah. Page number 4304,
Thank you.
the tab 63.
Yes.
I'm not going to go over the facts again, but you remember learned friend was taking you through the case.
Yes.
And arrived at a passage at the bottom of 4318.
Yes.
But as soon as it is proved that quoad the subject matter of the action, the defendant is the agent of the sovereign state, that in other words, the interests or property of the state are to be the subject of adjudication, the same result is reached. So hardly surprising then, in the light of that passage, that something beyond property, as it were, pops into the mind. Now, my learned friend, Mr. Chamberlain...
Well, agent interest in that sense presumably means vicarious interest.
Well, my Lord, we do say if one looks at the facts of Rahmatullah, as I say, I don't want to go into it, and if we read on, for example, to 398, 4323, the first full paragraph, if the action proceeded, this is Lord Simmons, it'd be the bank and not the government of Pakistan who would potentially have been liable. The government would still have been able to get its money from the bank. The concern was, if I can put it this way, that the bank shouldn't have to pay twice, and that amounted, and this is in the middle of the page, to a grave interference with the interests of the state. Now, my Lord, that can't, in my submission, easily be described as a direct effect. And certainly, as you know, you have our submissions. That's not true of Dolphus Meek. So at the very least, an indirect effect in my submission is encompassed by these early pre-statutory cases. But, my Lord, getting back to the point of principle, is there a principal difference? You have our case, I hope, which is that one starts with the rationale, as Lord Justice Brett did in the Parlement Belge. You start with the need for exemption of the person of every sovereign from adverse suit. And then the question is there a logical reason to limit the cases to property? We do not say that this is a limit, an immunity against embarrassment. We do not say it's an immunity against hurt feelings. We simply say, when properly analysed, here in these cases, there is, albeit indirect, the sort of effect on the interests of the state which is encompassed within the principle of indirect impleading. And, my Lord, it is important to remember that the Court of Appeal in Belhaj themselves did not see the doctrine as limited to property. That also appears to have been accepted in the case that my learned friend showed you. I'm not proposing to take you to it. This is Mr. Chamberlain yesterday, the Canadian first instance case of Kada, because at paragraph 35, 8275, in the judge, Mr. Justice Mosley, I think it was, his list of the three circumstances where sovereign immunity operates as a procedural bar, his third, the indirect impleading category, is when pleadings indirectly implead a foreign state by affecting its legal interests, not its property interests.
Yep.
Sorry, the reference is volume 20, tab 152. I'm sorry, page 8275.
Yes. Thank you very much.
Now, my Lord, one has to be careful about this case, I fully acknowledge. It's a first instance decision.
Right.
It's an application to amend.
Quite.
It seems pretty clear, if I may respectfully say so, that the judge did not have the benefit, if that's the way of putting it, of the full range of citation.
So what you're basically saying, if it's to be relied on, you're entitled to rely on that.
Well, my Lord, yes.
Understand your point.
And we've dealt with the broader points my learned friends rely on in paragraph 51 of our response.
Thank you.
Your notes, 11,499 to 11,500, I'm afraid.
Yes.
But insofar as the court confronts the issues with which this court is concerned, we simply say that the judge was wrong.
Yep.
Just because a finding of unlawfulness does not bind, because the state is not a party, does not mean that its interests are unaffected or that there isn't some legal effect. Lord, comparative law. My learned friend Mr. Chamberlain also cited the Garuda case, and again we've addressed it in our response, paragraph 52.1, MS 11,500, and I'm not going to take you to it. In short, our position is that the comments that were made there and relied upon were obiter. The court was not, in fact, dealing with an indirect impleading case of this kind.
What was the reference again?
I'm so sorry. Our response, 52, sub-paragraph 1, MS 11,500.
Yep.
It was the Garuda case Mr. Chamberlain referred to yesterday afternoon.
Thank you.
We've also dealt in our response, and again, I'm not going to repeat it, with Ms. Kaufman's citation of United Mexican States. Do you remember the two levels of decision? Again, in our response, paragraph 50, 11,499, and again, the simple but, in my respectful submission, important point is that the case, in that case, the issues before the British Columbian courts did not require any finding at all that Mexico had acted unlawfully, whether under Mexican, British Columbian, or international law. And indeed, in my submission, the striking thing, particularly given the way my learned friends put their case on the comparative law, is how very little they have been able to show your lordships, your ladyship, which is directly in point. Lord, so far as the convention is concerned, you have our submission on the words actually used. My learned friend Mr. Chamberlain took you yesterday to the commentary, the ILC commentary, to give you an insight into the intention of the drafters. But if I may respectfully say so, as a matter of plain language, the fact is that the final wording is very wide indeed, as all the commentators to which reference has been made have noted, including Dr. Grant, to whose work my learned friend took you yesterday, and indeed, as the Court of Appeal in Belhaj also found. The words are, to remind you, the proceeding in effect seeks to affect the property, rights, interests, or activities of that other state.
Yeah.
And as the Court of Appeal accepted, paragraph 45, MS 352, cannot plausibly be read as limited to property or indeed to interests in property. Now, my Lord, that is where one has to turn to what my learned friends have offered by way of interpretation of Article 6.2b. I made submissions about that in opening, about the way they were seeking to confine its meaning. In oral argument, again, Ms. Kaufmann was asked for her interpretation of what those wide words would cover, and with the greatest of respect, what she offered to the court did not, in my submission, do anything more than seek again to reduce their scope. Lord, so far as the question of legal effect is concerned, you have our submission. It's not least the point we've made about the 1978 Act, and I'm not going to go over that territory, but it does take me to my final...
Can I ask one question on 6.2b? I mean, is there any clue in the phrase "the proceeding in effect seeks to affect"? The respondents might argue that they're not seeking to do anything to the foreign states involved in this present case. The whole gist of this case is to do something to the United Kingdom.
But Lord, that's where one has to come back, and I'm now going to take you, I'm afraid, to what the issues actually are. Right. I think it's not before time. What they're seeking to do is to say that what the foreign states did was unlawful. Lord, it's very difficult in my submission when one looks at the allegations to say that they're not seeking to affect the interests of the foreign sovereign states.
But
and the breadth...
In the Dolphus Mead type case,
yes.
In the whatever the other case was you referred to a moment ago.
Rahmatullah.
Yes, the Rahmatullah case. They were positively seeking to get this cause of action on money, which they said belonged to them.
But, my Lord, in a very similar way, the effect was indirect. I'm not saying that there will be a direct effect here. I'm simply saying that it's indirect. I accept that it's of a different kind. The subject matter is utterly different. We submit that the rationale is the same. Lord, can I move you on to Belhaj and what is actually alleged? Belhaj, as you know, as it were, is my side of the case. Lord, I hope you'll forgive me for reminding you that this appeal comes here, in fact, on a strikeout.
Yeah.
It's a strikeout to strike out certain identified paragraphs of the pleading.
I understand.
And it's a remarkable feature of the argument that at no point has any party, including me, sought to draw your attention to the specific provisions of the pleading. And I don't wish to seem out of step or old-fashioned, but I do intend to mention them briefly now, not least in the light of various comments that my learned friend Mr. Hermer made yesterday. You'll remember that it's an important part of his argument to say that the claims he advances are English law tort claims brought as of right. Examples are paragraphs 7 and 8 of the Respondent's case at MS 175.
Yeah.
They rely on ordinary torts, they say. And that certainly in Belhaj is something rather important to remember, given the submissions that were made yesterday and indeed this morning.
Yep.
There is no international law claim made in either of these cases, nor in Belhaj is there a Human Rights Act claim.
Very well.
Now, the tort claims in fact advanced in Belhaj are summarised in our printed case.
Yep.
Where are they actually to be?
I'm sorry, my Lord?
Where are they actually to be found?
Volume 2.
In the case at 22 to 31,
Yep.
and that is MS 106, or rather it begins at MS 106.
Right.
And the reason I take you there, Lord, is because there you have all of the references to the pleading. This is a complicated pleading, and rather than...
Okay. Yep.
So, my Lord, you'll see the allegations set out under the various causes of action, the tort causes of action that my learned friend relies on.
Yep.
And the first one, and the most significant in terms of the number of states involved, is false imprisonment.
Yep.
Unlawful detention is alleged against 4 sovereign states.
Yep.
There were 5, but as you may have seen, China, against whom allegations were made, the case has been dropped.
Yep. Anyway, we've got the 4. Yep.
Now, my Lord, at the time the case against China was dropped, the claimants, who are now respondents, made clear that they did maintain their claims in relation to Malaysia and Thailand, and that was a point that learned friend dealt with in response to a question from my Lord Wilson. So there it is, that's what's actually being alleged. There is a claim against both Malaysia and Thailand, and the only safe place to find out what allegations are actually being made, and therefore the basis for this strikeout, if I may say so, is by looking at the particulars itself. We're proceeding on the basis of assumed facts. We're proceeding on the basis of the actual case pleaded.
Yes, yes.
My Lord, so far as the English tort claims is concerned, as you know, there was a third preliminary issue, and that concerned applicable law. There was no appeal from that, but the result of the issue was an order of the judge, which you can find at the second part of the core volume, MS 398 to 399.
Basically, it's summarised in your footnote 14, is that right?
Exactly.
Yep. Thank you.
And that sets out, first, at paragraph 2, in relation to the false imprisonment allegations, by reference to which state law the false imprisonment claims should be determined if they survive the strikeout and subject to a Section 14 point. Now, this has obviously now become important. Indeed, my learned friend places great reliance on this as a claim in which these choices of law issues will be important. But that means, first, that when the court is considering submissions such as learned friend Ms. Kaufmann's to the effect that making these findings that something is, or the conduct of the states is unlawful, is something that our common law could do, and which would not amount to an interference in a foreign sovereign's affairs, the first thing to remember is that on the basis of the judge's order, the legal rules which will apply will be those of the relevant sovereign state. So our common law will not be involved to that extent in the determination at all.
Yep.
Secondly, so far as, to take an example, the Malaysian false imprisonment is concerned, the relevant law will be Malaysian law. And that means that my learned friends envisage a situation in which an English court will set about determining whether Malaysian officials detained the respondents in Malaysia contrary to Malaysian law. And so, my Lord, we do say in the real world, and looking at this as Lord Dyson suggested the court should in Noor Khan realistically, that this, the question we pose would, how could it possibly be suggested that exercised by an English court in relation to the conduct, the unlawful conduct of Malaysian officials detained in Malaysia contrary to Malaysian law, would not amount to an interference over Malaysian affairs, or, to use the terminology that my learned friend Ms. Kaufmann deployed, an assertion of authority by this country over Malaysia. There is a world of difference in our submission between a case like this and, as it were, an ordinary tort claim in which you have an accident in Germany and you have to make your claim there because that's where the harm took place, by establishing your cause of action in relation to German law. And that's why, Lord, we do say, and come back to the initial point, that in considering these strikeout applications, one has to analyse what the claims would require the court to do. And the simplest summary of that is paragraph 76 of the Court of Appeal at MS 366, of which no criticism has been made by either party, as it happens, during the course of the hearing. And unless that framework, the actual reality of what is pleaded here, is borne in mind, one cannot properly assess the effect. And that's also why we submit that the issues here concerning the lawfulness of the actions of the foreign sovereign states, it now seems to be determined by their own laws, is indeed the very subject matter of the claim. The findings are a prerequisite to the court's finding of liability, and that is why we do rely on the analogy with monetary gold. Those phrases come from monetary gold and from the Nauru case, to which my learned friend Ms. Kaufmann took you, paragraphs 49 to 57, I commend to you, if I may, pages 7102 to 7108, and in particular, the whole of page 7106, including the important passage at the foot of the page and reading over to the top of 7107. Lord, unless there are any other matters, those are my submissions in reply on sovereign immunity.
It's very clear. Thank you very much indeed. Thank you. Mr. Eady.
My lords, my lady, the final lap. Just before Lord Clerk asked me where my document is, the document is here. Could I invite the usher to hand it round?
Thank you very much.
I hope it's helpful. I'm afraid I gave a strict instruction it should be 2 pages, but in the way of things it's 4. But it's intended to be a summary of the oral submissions with a link back into the case and giving you MS numbers where appropriate. So I hope that's of some assistance. I'm not going to take you through it now, if I may just hand it up so you have it as a note. That's the document that has been prepared. There is another document which is in the course of preparation, which we would seek leave to put in within pretty short order whilst things are still in our mind. But we got yesterday evening, as you will recall, from Miss Kaufmann, some examples which she had posed and said, well, these are the consequences in this hypothetical example. Does state immunity apply? Does foreign act of state apply in our case? How does all that work? You won't perhaps be surprised to hear that we think it's appropriate, with your permission, to put in a response to that. You may also not be surprised to hear that our clients are concerned to ensure that we are saying the right things in response to that, and so they are keen to be involved at least in the clearing of our response. And it is of some importance, because we all know how this sort of litigation works. The moment the government commits to any position anywhere, it gets cited back at it in the next case. So it's quite important that that document and what we say about that is done properly. So with your permission, we would like to respond, if we may, to that in writing, but we'll comply obviously with whatever timetable my Lord the President or the Court thinks is appropriate in relation to that.
What are you asking for?
Well, I was asking for, if I could ask for 7 days.
That seems reasonable. Obviously,
And then you've got it, sir.
Any response within 7 days. Not necessarily encouraging one, but obviously there should be a right to one.
Certainly. My Lords, my Lady, Mr. Phillips introduced the dollop of reality in relation to the pleadings in the Belhaj case. Rahmatullah is a great deal more simple because this comes to you by way of a ruling on a preliminary issue, and in the Rahmatullah Statement of Facts and Issues, which is in Core Volume 1 at page 94, you will see at the top of the page the nature of the preliminary issue, whether the claimant's claim, insofar as it seeks to establish either the defendant's liability in tort, however described, in respect of acts or omissions of US personnel while the claimant was in US custody in Iraq or Afghanistan, is barred by reason of, and so on. So that is what the Rahmatullah case is and is only concerned about. And that's all I need to say about the nature of that allegation. Can I turn first to Mr. Hermer's primary case? Because there is a basic difference of principle between us. He says that foreign act of state is, in its narrow version, a conflicts rule and no more, and that the more general principle identified by Lord Wilberforce in Butes must be confined so that it is simply a principle of judicial competence and thus has no application whatever in any claim in tort, because that is a claim brought as of right. I'm not going to go back over my submissions, but can I make 4 short points by way of response to that basic difference between us? Firstly, we respectfully submit that the UKOS Court of Appeal was correct in its analysis of the nature and form of foreign act of state, acknowledging foreign act of state as a freestanding principle, and most recently, for all the reasons they gave, the Belhaj Court of Appeal were correct to reach the same conclusion on the basis of all of the analysis of all of the cases on that issue in those authorities.
Can you add, what's your best case for the application of this principle? I mean, you would say the third ground in Princess Paley-Olga is an exemplar, but are there any other instances that you can clearly point to?
Well, my lord, we've got Princess Paley-Olga. We say that Blad is explicable on that basis. We say that Brunswick is explicable on that basis. We say that that's how Lord Wilberforce analysed those cases. We say that Underhill is an example of that principle.
Yes, you have to go across the waters to you have to go across the waters to the amazing volume of United States authorities.
Large numbers of authorities there, but we've also got, as you've seen, from Butes, I'm going to try very hard not to go back to Butes other than for very limited purposes, but we say that all of the cases analysed there, most of the cases analysed there, stand as an example of the application of that principle. Certainly Princess Paley-Olga is perhaps the clearest.
Yes, I mean, most of the cases fit easily into the conflict of laws category, don't they? And what you get is assertions that there is this other principle, but it's hard to find good examples of it.
Well, my lord, you've got Princess Paley-Olga as perhaps the paradigm example in the third ground, but you've also got Lord Wilberforce specifically considering whether there is that general principle in Butes. That's what he was actually doing. That was the question that he posed at the bottom of 931, or over onto answering it on the top of 932.
But then he didn't decide the case on that basis. No. He decided on a non-justiciability basis. Yeah. I mean, this. Well, as I understand it, conflicts of law is a rule of decision basis. In other words, it's a substantive legal principle, and act of state in the narrow sense is also a decisional principle. You adjudicate on the merits according to an absolute irrebuttable presumption that the acts of the foreign state are valid, even if they're obviously invalid in its own jurisdiction, or there's no law suggested which could validate them. Whereas the actual Butes principle is we're not going to say anything about it at all because we can't adjudicate.
My lord, it is. In its general form, it is. The only reason I was pausing when my lord was introducing that comment or question was because, as you will recall in opening, I took you through the detailed facts of Butes and the detailed analysis that Lord Wilberforce carried out, inter alia for the purpose of drawing your lordship's and my ladyship's attention to the emphasis that was actually placed on the conspiracy part of the claim.
Yes.
True it is, I mean, I don't want to get too early into the debate between states and transactions of states, but it was essential and integral to Lord Wilberforce's reasoning, as one can see from the numbered paragraphs where he identifies in numbered paragraph 1 the transactions between states. That's the judicial competence side of things. But he also placed reliance upon one of the American district courts' references to shutting the thing down on the basis that it involved an allegation of conspiracy against a foreign state. And he then came back to that, or Wilberforce then came back to that, in the context of his analysis in the second of his numbered paragraphs. Yeah. And then you see, when he deals with judicial competence, I've got the pages in my head, we'll go to them I'm sure in a moment, but you remember the paragraph where he deals with judicial competence at the top of the page, and the paragraph immediately below that deals with conspiracy. So he's got the two strands running through, so it isn't actually right, even on an analysis of Butts, we respectfully submit, that Lord Wilberforce was restricting the dispositive reasoning solely to the usual you can't talk to, states can't rule on transactions between states and treaty matters and matters of that kind. But I think, my Lord, the question you started with, what's the best application prior to Butts, if I can put it that way, it is Princess Paley Olga.
Yes, hasn't it?
And one can have an argument about high seas in Blad, and I was...
And of course they were looking at the old American decisions, and we know that Sabatino has sabotaged the reasoning.
Well, I'm going to take you back to that, if I may, in a moment, because what has actually happened is that the English courts, starting in Butts, perhaps starting even earlier than that in Luther and Sagor, as Lord Collins pointed out in Lucas Jones, they dragged over from America Underhill 1 and Underhill 2, as Lord Collins points out in Lucas Jones, and Urchin, took the principles that are too well known to be recited, put them into English law, and applied them. That provided the principal answer to the rhetorical question that Lord Wilberforce asked at the end of 931. And then what then happens in America, true it is, Sabatino moves on, and I'm going to take you to that in 1 second, but Lord Wilberforce himself was aware that Sabatino had been decided.
Yes.
It had been decided before Butts was decided. So he looked at Sabatino. Perhaps it may be worth...
Have we, the amendment, which I think did become valid, the Hickenlooper amendment, is that post-Butts? Because the American case law, American position seems to have moved on into a completely unfamiliar sort of synergy between, or symbiosis between the courts and the executive.
I thought it was pre-Butts. It was a response to...
It was a response to Sabatino.
Early decisions on the question of Cuban assets. Yes. It's tailor-made for Cuba. It's backdated to the very date of the Cuban Revolution.
Yes, I see. Anyway, there we are. Sorry, I don't want to take you out of your way.
Yes. No, can I pick up Sabatino in 1 second? Because the second of my submissions, of the 4 submissions, touches on this point, and it is that the contention that my learned friend makes simply can't survive when set against the case law that has been considered when properly analysed. I mean, his case does, on this part of his argument, involve the contention that large tracts of US and UK case law deeply misunderstood a whole series of cases which are actually properly explicable either solely on the basis that they're conflicts cases or solely on the basis that they're sovereign immunity cases. And perhaps the best example of that is the Princess Paley Olga case, the third principle, my learned friend, the third part of that, you'll recall. But you will recall, without needing to go back to it, the facts there, where the Court of Appeal disagreed with Mr. Justice Warrington at first instance on precisely that point, that additional point. So my learned friend said, well, actually, look at the cross-examination. It's all about the internal law, and there must be a question here to do with the constitutional setup in Russia at the time. That simply doesn't fit with the basic distinction that's drawn between the 3 grounds argued, or indeed the reasoning of principle that the Court of Appeal applied. I don't need to go back to Blad and Brunswick, because if I can take Lord Wilberforce in Butts for the final time, I don't need to go back to those, because whether I'm right or my learned friend is right, the short answer to the correct characterisation of those cases and what they stand as authority for, I can take, I don't mean this impertinently, but I can take from Lord Wilberforce. You will recall the structure of that part of the judgment, 1789 in the MS numbering.
Thank you.
That's the 931, 932 memory I have. But you remember that the rhetorical question is posed, identifying the nature of the principle in question by G on 1789. The question he poses is, does there exist in English law a more general principle that the courts will not adjudicate from the transactions of foreign states? That's the question, and he gives, the answer he gives to it at the top of page 932. And for this purpose, therefore, what then happens in that reasoning is that he identifies where he finds that principle in previous domestic case law. The first trace of it, he says, at B on 1790, is Blad.
But this is the more general principle of non-adjudication, judicial restraint or abstention, if you look at G to H on 931.
Yeah.
My Lord, this is the more general principle. But then, I mean, again, I'm not going to re-argue
The distinction, if you look at, is at D. It's one thing to assert that effect will not be given to a foreign municipal law or executive act if it's contrary to public policy or to international law, and quite another to claim the courts may examine the validity under international law or some doctrine of public policy of an act or acts operating in the area of transactions between states. So he's treating both the conflicts principle and the Paleolgan third ground principle as in one category of adjudication, but he's treating the Butte's gas case in another category of non-justiciability, isn't he?
Well, my Lord, I think what the Court of Appeal did in UKSC, if you will recall, is to go through all of these cases again, analyse them and see where one ended up. And what they eventually said was it's all become merged into a single principle, effectively.
Yes. Well, that's what we have to decide, really.
It is. Well, it is and it isn't. We respectfully submit that the general principle is there, and it applies in the form that you see at the bottom of 1789.
Top of 1790.
Exactly so.
Okay.
Well, what is the general principle? That it is that in this type of case, Princess Paleolga, really the courts simply say, we're confronted with a complaint about a foreign act, that's not justiciable. We're not going to say anything about the case, really. The case must stop.
Yes, exactly so. And I said I would go here for Sabatino.
Yep.
If you go to 1792, you will see what he says about Sabatino. So it's at least worth noting that before he gets to Sabatino, it won't have escaped him that they've moved on in terms of their analysis. But you will see that he's drawn the principle, or support for the principle is just identified from Underhill and Hernandez and Urchin on the previous, or the facing page. Yes. But then we get to Sabatino, and you see what he has to say about Sabatino between B and C on page 1792. And that was the reason, I think that was that paragraph that I had in mind when, in response to a question I think Lord Sumption asked me on the opening day, I said one needs to be a little careful about the opening paragraph in that section of the Sabatino judgment itself, because it isn't saying that this principle, the broader principle, doesn't have a basis in international law. It's just saying, as Lord Wilberforce says here, it isn't compelled by it.
Yes, but the precise extent of what he was saying is a matter of debate, and one has to see it in the context of how he applies it, doesn't one, to the 2 points he makes on 1795. And they're very much to do with high-level international, interstate issues, aren't they? look at item 1 opposite letter B and item 2 opposite letter E, and the way he explains the concerns to which they, or the issues to which they give rise.
Well, yes, my lord, as long as you don't stop reading at E.
Well, yeah, I agree, but
But my lord is right. On the facts of that case, yes. But the reason I said that the two strands were interwoven was because on the facing page 1796, you see them both referred.
when you look at G, just above G, involves establishing the actions were at some point unlawful. Unlawful in this context cannot mean unlawful under any municipal law, which is what it does mean here, but under international law. So there's nothing about municipal law in that case.
My lord, no. But the reasons, the two strands coming together, one sees, I respectfully submit, at the top of page 1796, between A and D. Anyway,
Quite.
you probably know Buttes by heart at the end of this, but those are the points I wanted to emphasise and re-emphasise in relation to Buttes. My lords, my lady, you will recall, this is the third point,
Yep.
that the key thing considered by the Court of Appeal in Belhaj itself
Yes.
was whether or not, and this was the argument that was mounted by Mr. Hermer below and has been mounted again before you, was whether or not the principle of foreign act of state is in effect confined so that it is a principle of judicial competence. And the Court of Appeal, rightly, we submit, rejected that as a proposition. My learned friend implied, without, in fact, going back, didn't even take, my lords and my lady, back to Shergill, no doubt because he felt it was too well known to the court to need to go back to it, but, and it's a relatively short bit, but he referred on any number of occasions during his submissions to the Shergill framework, as he put it. That seemed to be being used as a shorthand for judicial competence is the limit of the principle, and you so held in Shergill. That seemed to be the suggestion behind the repeated use of that phrase. The difficulty, of course, with that is that he didn't, in fact, have any answer to the points that I made in opening, any significant or substantial answer to the points I made in opening, which were, first of all, as you will recall, that what the court was doing when it was analysing Buttes at 39 to 40 of Shergill was to deal very specifically with the approach that the Court of Appeal had taken to judicial competence in the particular context of that case, namely about religious issues.
Well,
and
the
religious
judgment in
disputes.
Shergill had nothing to do with act of state. It simply wasn't relevant.
It didn't.
No.
But more specifically on the general principles, and it is of some interest and was treated as some interest by the Court of Appeal in Belhaj, as setting out the general framework of how act of state works and how it fits. When one gets to those parts of the judgment, which are perhaps more interesting for our purposes, he had no answer to the core point that we made, which was that the court there, even on that high level that it was analysing things and even recognising the fact that you didn't need to consider and didn't have cited to you Kuwait, UKOS, Pinochet, Nissan, nor Khan, none of those were before the court in Shergill. But even leaving that on one side, the headline analysis at 42 and 43, as I submitted in opening, draws a distinction between effectively claims as of right and discretionary claims, but within the claims as of right section, para 42, the penultimate sentence made it clear that, that one of the principles that cut into that was act of state. So when you get into that territory, even if the claim is as of right, the court can't go there. Once it's identified it, that's why you said it was rare, because it operates as a cutout in terms of adjudication, even where the claim is a claim as of right, if I've understood that penultimate sentence.
In that sense, it begs the question for our purposes as to what the forbidden area is.
It does.
So one gets...
It does, but it identifies that that the principle that you identified earlier on in 42 exists and has that effect.
Yep.
And so, my lords, the fourth point, the fourth point is that if his conception of the limits of Buttes is wrong, then that is pretty much the end of the primary case. it isn't an answer if he's wrong on the basic apprehension of what foreign act of state is doing and its nature and effect from the case law. It doesn't help him to say, well, there are here manageable judicial standards. And the reason it doesn't help him is because it doesn't touch, that wouldn't touch the rationale or the principle correctly understood as we submit it should be. It isn't solely based, as the Court of Appeal in Belhaj concluded, on a principle of judicial competence.
Yes.
And in that respect, on the rationale, he equally didn't have any real answer to the concern about how on earth a court could go about deciding these sorts of issues. The Part 20 point, the how do you make a determination, take Rahmatullah, you've seen the nature of the preliminary issue, 10 years in US custody, series of allegations about what the US did or didn't do. How on earth do you get to a position in which you can determine those issues? And it isn't an answer to that to say we now have the Justice and Security Act. So we do. The Justice and Security Act, however, in response to Al-Rawi, as you will be aware, allows the government in certain circumstances where there are national security concerns to apply to the court for a closed material procedure. But that doesn't solve the problem of the absent state. It allows, in certain limited circumstances, the court to permit sensitive material which would otherwise be excluded from its consideration by PII to be considered for the purpose of actually determining the issues that arise. But it simply is not an answer to the very, very serious practical problems that would arise. My learned friend said, well, we can make an application under Carnduff if we get to it. As I recall the exchange that I had with Lord Mance in relation to that, it wasn't so much, as it were, an invitation to make a Carnduff application. It was more by way of echo. One has that problem, and that problem, namely the problem created by Hamlet without Claudius or the Prince, that problem, as it were, sounds into that Carnduff line of thinking. How can you sensibly try a claim, not merely by saying the actor has to walk in with his hands up? That was the Sir John, Lord Justice Law's analogy in Carnduff, but where you don't even have the primary actor on the stage. So we respectfully submit that that is not a good answer. And likewise, in relation to the submissions that my learned friend Mr. Chamberlain made this morning, which were principally directed in their focus on monetary gold in East Timor, on the problem of sovereign immunity, state immunity that you have to deal with, and indirect in pleading. But the reality is that East Timor was relied upon in my opening for a slightly different proposition, again by way of, as it were, international echo sounding. We respectfully submit that that case, that line of cases, including the Larson case, are interesting and authoritative because they involve international tribunals, including the ICJ, operating under its own particular rules, which obviously didn't apply in the arbitral context, in the Larson context, but the ICJ themselves recognising the difficulties of the absent state, the difficulties of ruling when you have an absent state. Well, my lady, on this aspect as well, I think my Lord Neuberger was interested in the Lucasfilm case, which is in bundle 3 at tab 27.
Yeah. Yep.
And can I just invite you to note, so it's tab 27, it's MS 2435 it starts at.
Right. Which bundle?
Authorities 3,
Thank you.
tab 27.
Yes. Got it. Thank you. Yep.
Just for your note, it's considered this case in the UKOS analysis in the Court of Appeal, bundle 1, tab 3 at paragraph 63 of UKOS.
Thank you.
So you get some help from that. But I think the passage that think my learned friend took you to it for the proposition that not every governmental act is an act of state, and of course that is unimpeachable. There are some that are commercial, for example, but nothing in Lucasfilm supports the proposition or a contention that acts which plainly are iure imperii, but nevertheless do not have the character of act of state. But I think the paragraph my Lord was interested in was in para 86.
That's right.
My Lord, I think the only reason for going back to that is to make 2 points. One needs to read the entirety of the section from 81, para 81 and following, to see just where this fitted in.
Yes.
This was a very, very specific application involving a very delicate question, no doubt, of intellectual property law, and whether one could enforce foreign copyright. But a very specific context with no real consideration at all of the limits of act of state, of foreign act of state, where the acts were iure imperii.
Well, the only point is that it struck a chord, not least because it's from Lord Collins, as well as Lord Walker, with the submission that was made that in England the foreign act of state doctrine has not been applied to any acts other than foreign legislation or government acts of officials such as requisition. That was really, I appreciate you can say that that is to be read in the context of the previous 5 paragraphs, but is that right, that you accept that proposition, expressed widely rather than narrowly, that it's only been applied in relation to those sort of acts?
My Lord, I think as a matter of fact I can accept that,
Yes.
as long as you underline the words such as, and as long as one recognises that what Lord Collins was not doing was to seek to identify the limit of the principle.
No, to build on that and say ergo, that's the principle,
Quite.
I accept. And you have the point that why, as a matter of principle, should it be limited to those sort of acts? I appreciate that.
If it applies to that,
I appreciate
how much more so is the principled answer.
understand
But I just wanted to place it in its context, because you can take it out of context and
Perfectly
say, well, that's in some ways suggestive of a limitation. My respectful submission is that neither on its face nor in context
Understand.
is it doing that. Then my learned friend made a series of submissions in relation to the indistinguishability, as he asserted it, of our context from other contexts in which the court might get sucked into examining the conduct of foreign states. And the short answer in relation to that, perhaps the shortest answer, is that the Court of Appeal themselves considered that issue in the Belhaj case at paragraph 91. They gave a description of the grouping of cases as involving, as it were, specific explanations for why each of those examples did in fact involve the court doing what they were doing, so statutory exception or within Kirkpatrick or for some other reason. But perhaps as importantly,
Which paragraph was that?
Paragraph 91
Thank you,
of the Court of Appeal in Belhaj. But despite that, perhaps the more important point is that despite that, the court then went on, nevertheless, to conclude that foreign act of state did indeed exist as a principle and rejected my learned friend's primary case. I mean, so one has, by way of example, I think it's an example that my learned friend Miss Kaufman relied upon as well, one has, as an example of another category perhaps, Human Rights Act claims, which, as you know, are not in issue for the purpose of the principle that you have to consider in these cases. But they can perfectly happily sit within that framework on the basis that the court will be dragged into whatever territory it does get dragged into for the purpose of determining claims that Parliament has said need to be determined in that way. But we would also invite you to note, in relation to Human Rights Act claims, which my learned friend Ms Kaufman particularly placed some reliance, but my learned friend Mr Herman also, that in truth there is a pretty close marching hand in hand with foreign act of state in this respect. And that is because, as Mr. Hermer accepted, there is no question, and could be no question in the Belhaj case, of Mr. Belhaj ever having been within the jurisdiction of the United Kingdom. And we know that in the Rahmatullah case, he was within the jurisdiction of the United Kingdom for a single day, and thereafter, as Mr. Justice Leggett has specifically held, was within the jurisdiction not of the UK and not coterminously of the UK with the US, but solely within the jurisdiction of the United States. There was some suggestion that in some way, shape or form, Article 3 transfer cases would drag the court into substantially similar territory to the territory that we say you are excluded from, should be excluded from by the Foreign Act of State doctrine. But the court will recall the basic and principal position in relation to Article 3 transfer claims, in other words, claims where an individual is moved from one state to another state. The focus in such cases is on the state of affairs and the existence of risk at the point of transfer. That's how you make good what is traditionally known as a Suring type claim, where you're moving an individual from one jurisdiction to another. More specifically, the test in those cases is whether or not there are substantial grounds for believing that there exists a real risk, for example, of ill treatment if transfer is to be effected. What that line of case law does not do is to render one state liable under Article 3 for everything that happens thereafter in the jurisdiction of the receiving state. That is simply not in any shape or form what that principle is directed at, nor is it how those cases under Article 3 work. And you see that, if you just take up our response for a moment, if you would, our response document.
Yes.
And just go to footnote, saves me going to the authority, footnote 19. You will see a quote from Suring. This will be deeply familiar, I'm sure, to most of you. So it may be loose somewhere. Perhaps shall I read out the quote from Suring so you have it, you get the point immediately. The establishment, said the court in Suring at paragraph 91, the establishment of such responsibility inevitably involves an assessment of conditions in the requesting state against the standards of Article 3 of the Convention. Nonetheless, said the court, and this carries echoes into the principle of the argument, nonetheless, there is no question of adjudicating on or establishing the responsibility of the receiving country, whether under general international law or under the Convention or otherwise, insofar as any liability under the ECHR is or may be incurred, it is liability incurred by the extraditing contracting state by reason of its having taken action, which has as a direct consequence the exposure of an individual to prescribed ill treatment. So they're not merely holding back, recognising that they're holding back from adjudicating on the responsibility of the receiving state, but that, as that passage indicates, and as the Suring case law already indicates anyway, what is being done there is to examine the point of transfer, to examine the nature of the risk, and not to rule on wrongdoing or otherwise by the foreign state, but simply to identify whether there are substantial grounds for believing that there exists a real risk. So a very different situation. And we urge very considerable caution in approaching the Al-Masri cases and the Al-Nashiri line of cases if those are being relied upon to seek to establish the proposition that the court will necessarily get dragged in the transfer line of allegations, that the court will necessarily get dragged into investigating and adjudicating upon what actually happened in the hands of the Americans in Iraq and Afghanistan. We respectfully submit that those cases are very different and explicable on their own facts, not least because it all occurred in the territory of Macedonia, which was the respondent state so far as that application was concerned, but also because there is a series of a species of reasoning that run through all of those judgments, effectively along agency lines, if you will, imputing to Macedonia the actions on its territory undertaken by the Americans. So a considerable note of caution before assuming that those cases indicate in any way that the court will, in the transfer claims, be dragged into this investigation and adjudication of what the Americans did or didn't do territory. My Lord, so that's, my lady, that's the answer we respectfully submit to the indistinguishable from other cases. I made my submissions in opening on A number 2, the torture case. I'm not going to go back to all of that. I do respectfully continue to submit that it was critical to the reasoning of the House in that case to have regard to Article 15 of UNCAT of the Convention Against Torture, because it was the test derived from that is the statement established to have been made as a result of torture, on which Lord Hope founded in his reasoning for the majority as to what the test should be. But in any event, none of the examples that my learned friends have provided support the proposition for which those contexts appear to be cited, which is that their existence removes the principled underpinning from our argument that a separate doctrine of foreign act of state exists. We respectfully submit that they don't do so, and that they're all properly explicable, as the Court of Appeal in Belhaj found consistently with that principle. So then my learned friend Mr. Hermer's secondary case, so far as that is concerned, can I pick up a couple of points in relation to that? Territoriality first. The premise, of course, for his alternative or secondary case is that, subject to limitations, the principle of foreign act of state exists, as we assert, and as the Court of Appeal in Belhaj found, and it operates as a general principle to prevent examination and adjudication on sovereign acts of foreign states. If that is so, we respectfully submit, my learned friend Mr. Hermer had no good answer to why such a principle should be restricted simply to the territory of the foreign state. The act itself occurs outside. The acts that states do outside their territory are just as sovereign and can be just as sovereign as acts that they do inside their territory. The rationale for the principle as we identified them, sovereign equality, comity, difficulties of adjudication and so on, those are just as much, if not more, engaged when the act is sovereign and outside as they do when it's sovereign and inside. And it's no answer to say...
In the Princess Paley case, Lord Justice Russell specifically limited the state immunity point, or act of state point, to acquisition of property within its territory, not outside its territory.
My Lord, in my submission, that needs to be seen in the context of that case.
Well,
that was there was no need to determine anything else in that case, because all the relevant acts...
About the effect of legislation, and legislation is virtually by definition territorial,
exactly.
Whereas executive acts are not.
Yes. My Lord, that was the next point.
That's what they all say. Yes.
Yeah. Well, I better hand over page 6, you can check. I offer it, the court can take it as having been offered up. The notebook has been offered.
Handwriting's like mine, Mr. Eady. We won't get any further, but I obviously accept your word, yes.
But no answer to say legislation, because legislation starts from the different presumptive basis of in effect within territory, is the short point. And that is no doubt why the cases that we've seen I know the passage my Lord was just referring to in that case, but there are lots of references in all the other cases to abroad, 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 abroad. One goes through Buttes, and Lord Wilberforce is repeatedly saying abroad, back to Brunswick and all of that. The Kirkpatrick exception, or limitation, my learned friend relied upon Sharon. He did so below. It didn't help him below for the reasons given.
Just before we go to the exceptions,
Yes.
Can you just help me? If we're talking about legislation, as you say, usually territorially based, do you accept that there is a public policy exception?
When trying to enforce legislation?
Yes, I mean, if legislation is, you're presumably going to come to that at some point. It's in the Private International Law Act, 1995.
One has that exception?
Yes.
Yes.
And therefore one is adjudicating upon the foreign sovereign act of passing that legislation and saying that this is disgraceful.
My Lord, yes. Now we have statutory authority. That isn't a good principled answer because it reflects the common law, as it was before.
Yes.
But nevertheless, there are limited circumstances in which that will be done.
Yes.
Of which Oppenheimer and Catamol is the paradigm example.
Right. But you say when one's dealing with acts, is there or is there not a public policy exception?
We accept, and the Court of Appeal then goes on to reason that there is a public policy exception. The debate between us here is as to how it applies. What is the nature of it? What should it be? That's truly, it might be thought, the battleground in this appeal, because the Court of Appeal said we need to go beyond Oppenheimer and Catamol and Kuwait. I'm going to come to that.
Yeah.
Yes.
The nature of it and how does it work, and when you're touching.
Is there any case in which the public policy exception has actually been applied to an executive act as opposed to legislation?
Well, Kuwait is such
Kuwait
a case, is it
is
not?
close to it at least. I mean, I was pausing on Kuwait because there was a decree involved.
legislative decree nationalising the property of the Kuwait Airlines.
That's legislation. The issue, I mean, certainly I looked at my judgment at first instance, as one tends to, and I certainly saw it that way at first instance, as falling within that category. I think one has to analyse the House of Lords. But I would think that it's difficult to say that it is analogous to Butte's gas, isn't it? I mean, the international law element is there, but was being deployed, or do you disagree, as part of a domestic law evaluation of whether the public policy of the domestic court would be?
My Lord, it was, but they nevertheless considered act of state and how it should work in that context. Right. And we do respectfully submit that if one goes back to the underpinning of principle, once one accepts that it can't just be restricted to legislation, it would be very odd if it could, because they're just as much sovereign acts as legislation. Yes. Then we're into a different argument about confinement within territory or not.
So the question is not about whether there is in principle in your case, but how it applies.
How it applies.
When it can.
We've never said in relation to the Court of Appeal they were wrong even to hold that there was a public policy limitation. The debate has always been as to the nature and extent of that and how it should work. And in particular, the debate is focused, and that's where Kuwait comes relevant again, but in particular it's focused on whether or not you have to apply the clear standard, as it were. I summarise, but that's how we deal with it.
Yeah.
My Lord, Kirkpatrick, just before we get to the public policy exception, if I may, Kirkpatrick, again, my learned friend relied on Sharon. We take our stand on the Belhaj Court of Appeal at paragraph 73. We try to rely on it below for substantially the same reasons, and they rejected that. We respectfully submit they were right. Their reasoning is consistent with the Court of Appeal in UKOS's reasoning at paragraph 97. So Sharon is Court of Appeal UKOS 97 and Belhaj Court of Appeal 73.
Yeah.
I think my learned friend Mr. Hermer handed up Ramirez and Weinberger.
Yes.
Can I just invite you to flag one more
Passage. I know. Better thick one, it's got tricky tags. Yeah, where do you want us to look, Miss Breedy? Which page?
1542.
Thank you. Yep. So we've looked at that page, we want to look at another.
I want you to look at the left-hand column.
Right.
My learned friend invited you to
Right
sideline the right. Can I
balance the
ambidexterity?
Yep.
But you'll see effectively what is said if you just read briefly that first full paragraph.
Finally, we note.
Exactly.
Bertie.
The point's obvious.
Thank you. Yeah. Yeah.
Then the public policy exception, if I may, and sovereign act first of all, and briefly, and then proven breaches. So far as sovereign act is concerned, again, my learned friend sought, as he did below, to cut out torture, effectively saying that can't be a sovereign act in nature. But the short answer, again, is that we respectfully agree with the Court of Appeal in the Belhaj case at 78 to 80. And when and if you go back to that, could we invite you to note that the reasoning from Jones and Saudi Arabia that they relied upon, see the quote at paragraph 79 in the Belhaj Court of Appeal, is not, in effect, addressed or explained away by Mr. Hermer's submissions on this point at all. So far as proven breaches are concerned, we do respectfully submit that both Oppenheimer and Kuwait for this purpose are very important. Our learned friend simply asserted, and said he was going to come back to it and then didn't take you to it, asserted that the Court of Appeal in Abbasi is inconsistent with all of that, but again didn't have any real answer to the point I made in opening, which was that the court in Abbasi, even though there had been judicial decisions in the United States, was still very, very cautious not to trespass into this difficult territory, and that is the very point that Lord Justice Simon Brown was making in the CND case. So there's nothing inconsistent with my submissions in Abbasi. On the contrary, it stands as an example, as indeed does the case that my learned friend Mr. Chamberlain referred to for the different purpose, Rahmatullah, in the Supreme Court, where Lord Kerr was entirely understandably and consistently with our submissions, extremely cautious not to delve into findings involving the foreign state. And so the starting point, so far as this is concerned, is the Court of Appeal in Belhaj correctly acknowledging in 114 that they would have to go beyond Oppenheimer and Kuwait. And we made the submission in opening that that reasoning, the clarity, was a critical feature of those cases, especially in Kuwait, especially Lord Nichols at para 26, not merely incidental, and that was the proper principled approach for the basic and simple reason that unless you apply that principle, you risk not merely cutting across the principled underpinning or rationale of a foreign act of state, but you risk destroying it. And on that point, can I invite you, without turning it up again, to note in the Larson case, do you remember the international arbitration case, authorities 28 tab 223, could I invite you simply to note paragraph on this point of clarity 11.24 on X page number 11,115, where they also indicate that clarity is needed.
My Lords, my Lady, Habib. I think, need to deal with Habib, because it's been referred to on a number of occasions, and the Court of Appeal placed some reliance upon it below. It's in bundle 21 of the authorities behind tab 160, MS 8636. The Court of Appeal relied upon it in the Belhaj case between 96 and 102 of their judgment. You've been taken to various bits of it, and we respectfully agree, given the weight that the Court of Appeal placed upon it in the Belhaj litigation, that it is one of those cases, perhaps one of those few cases that the Court might feel appropriate to read in full. But can I make submissions about it with it open, so that you can tax me, if you will, on the submissions that I make? The first point that we make about it is that there is, with the greatest respect to Justice Jago, a real concern about the analysis in this case of the English law principles of foreign act of state and their rationale. She analyses the English cases and deems them supportive of the position that she ultimately reaches, which is that the claims can just simply proceed to trial. She particularly analyses the English or United Kingdom cases between paras 97 and 106. And I'm not going to trawl through all of that reasoning now, but we do respectfully submit that that does not really do justice to the sort of analysis that you now have the benefit of from the Court of Appeal in England, both in the UKSC case and particularly in the Belhaj Court of Appeal judgment. And so what we would invite you to do, and perhaps I can make the point shortly in this way, what we would invite you to do is, as it were, to transpose the reasoning of Court of Appeal UKSC and the reasoning of Court of Appeal Belhaj on foreign act of state. Transpose it into that judgment at that point. And if you do that, we respectfully submit, what you would actually have ended up with in this judgment is not an ability to say, look, that case law supports my conclusion, but the need to explain how the conclusion that is reached by the court in this case could have been reached consistently with that case law. But the short and respectful point is that her analysis of, with which the other members of the court essentially agree, her analysis of the English case law there does now, we submit, need to be read alongside UKSC Court of Appeal and Belhaj Court of Appeal.
Can you be a bit more specific about that?
My Lord, yes. You have the initial analysis there. It's a point that perhaps hits most closely to the argument here in relation to my points about the need for clarity of both law and fact, the Kuwait-Oppenheimer point, which she deals with at paragraph 110. This was the passage my learned friend took you to. And essentially what she says in this paragraph, on the back of the English authorities, is that the cases do not support a distinction between known and alleged violations. That's her first answer. And the second answer is to say, and there is no reason in principle why it should do. That is the essence of the reasoning. I hope I fairly summarise it in 110. Yes. And my respectful submission is, in relation to the second sentence of that paragraph beginning, however, cases do not support a distinction between known and alleged violations. My respectful submission in relation to that sentence is, they do. That's exactly what Oppenheimer is about. That's exactly what Kuwait is about in relevant respects. And moreover, that was at least the implicit conclusion of the Court of Appeal in Belhaj, because they acknowledged that they would have to go beyond it in 114 of their judgment in the cases which you're considering on appeal. So that's what we say about that, and to some extent it ties back with the analysis
that she's given earlier of the domestic cases, or of the English cases, the United Kingdom cases. And then she says, well, there's no principal distinction, basis for such a distinction. And we respectfully submit that there is. And the reason that there is turns on whether we are right or whether my learned friend is right on the basic underpinnings of the doctrine of foreign act of state. If my learned friend is right and judicial competence is all and exclusive, then her points are good. But we don't even reach this stage because foreign act of state doesn't exist up to this point so as to need a public policy limitation. If, on the other hand, I am right, and I would add, respectfully, the Court of Appeal in Belhaj were right to reject my learned friend's primary case, then the basic underpinning or rationale for foreign act of state lies in the doctrine of sovereign equality, to which can be added comity and difficulties of adjudication and so on. But sovereign equality is where the Court of Appeal in Belhaj located the rationale. And if that is the position, assume for the sake of argument that is right, that that is the nature of the rationale, it immediately becomes obvious why that rule, that requirement of clarity, is necessary. Because if you could simply turn up and make a serious allegation, or even turn up and make an allegation of extreme seriousness, such as torture, if that was enough, then the court would inevitably be sucked into investigating and adjudicating upon the legality of a foreign state. And as I submitted as my final point in opening this appeal, the problem with that is that it doesn't so much tailor the limitation, it destroys the principle to which the limitation is said to be an adjunct. So we respectfully submit that that second part, the no reason in principle part for a rule of clarity, is answered if we are right as to the underpinnings and the rationale for the principle which we espouse, which is the premise on the basis of which one reaches paragraph 110.
Yes.
So that's our fundamental point about Habib.
Thank you.
Trying to focus it in on that. I think my Lord Wilson asked my learned friend a question as to whether or not this case wasn't at least also explicable or potentially complicated, to put it at its lowest, by the Australian constitutional position. And our answer to that is that I'm not sure I can rely upon that constitutional position as a complete answer, because I have to grapple with the points I've just made, because they exist as freestanding issues in the judgment. But my Lord Wilson is entirely right to draw attention to that, and he's right to draw attention to that because the analysis of Justice Jago is broken down into three parts, as one sees from the beginning of her judgment, 8655, paragraph 56, where she identifies the three questions that then shape the nature of her judgment. Those are the questions that are then broken down and answered in the three sections of her judgment. And the third of them, to which my Lord Wilson drew attention, starts at page 8670, just above paragraph 121. And there plainly was a detailed consideration being given to the Australian constitutional and statutory context of the Constitution, of course. I was going to go there. My learned friend asks you to sideline, and I'm entirely content to ask you to do the same. Could you sideline particularly 125 when considering those matters, because they set out the relevant constitutional provisions? But I would also invite you to take that sidelining exercise down to the end of 127. And the reason that I ask you to take it down to there is because you see effectively the punchline of the constitutional point reflected in the second, or the first and second sentence, sorry, the first three sentences perhaps, of paragraph 129. So the reason I said the position was complicated by the constitutional position is A, because of this little group of provisions, effectively creating long-arm jurisdiction, if I've understood them correctly. So a bit of long-arm constitutional jurisdiction, but there was a separate constitutional principle involved in this case, which, as it were, runs through the reasoning of at least some members of the court. If one goes back to the judgment of Justice Parham, I'm afraid I don't know whether Justice Parham is a man or a woman, but Justice Parham is suitably neutral. If you go back to that judgment, and the reference, I think, to turbid waters rang a bell.
Page, paragraph.
8644.
Yes, got it.
Para 24. This was the dispositive part of Justice Parham's reasoning. And you'll see that in Australia they have another constitutional principle. So you've got one which is to do with long-arm jurisdiction, effectively, the constitutional issues. You've got another here, the final sentence of 24. This is effectively, we don't need to get into this Act of State business because the Act of State doctrine, whatever it might be, has no application where it's alleged that Commonwealth officials have acted beyond the bounds of their authority under Commonwealth law. And then there's a whole citation of cases and pages of analysis on that point. You will also bear in mind, going back to the Chief Justice's judgment, that they place considerable and strong reliance, both the Chief Justice and Justice Jago, on the Australian criminal legal position, and they effectively reasoned from the criminal position, where they had had an extension of the criminal jurisdiction so that it became effectively universal. They reasoned from that to say, and therefore we can try the civil. Yeah. And that line of reasoning, integral to the Chief Justice's judgment, it might be thought is not terribly easily reflected in our jurisprudence, see Jones and Saudi Arabia. So we respectfully submit that that Australian line of authority, whilst of course powerful in part, A, has its own complications, so some care is needed, but B, when one comes to the critical bit, which is the analysis of effectively foreign act of state, the points that I've made hold, we respectfully submit. Very nearly there. Article 6 ECHR, 2 short points only. Lord Sumption raised with my learned friend the question whether there was, for the purposes of applicability, a distinction to be drawn between state immunity, brackets jurisdiction, and foreign act of state, brackets non-justiciability, or a principle of judicial restraint, for the purpose of the applicability rule. My respectful answer to that and submission is that they are, of course, that is the concepts of jurisdiction and non-justiciability in this sense, they are, of course, conceptually different, but for this purpose not distinct. And for this purpose not distinct because you will recall that although we can't say that the reasoning of Lord Millett is directly transposable into foreign act of state, nevertheless, there are sufficient similarities between the principles to render the outcome the same in principle. And in particular, you will recall that I took you to the judgment of, or to the speech of Lord Hoffman in Matthews for the principled underpinning of the distinction between procedural and substantive in the Article 6, however difficult in the Article 6 case law. And we respectfully submit that if that is taken as the lodestar, then it works just as well for justiciability, although on a slightly different basis. And the slightly different basis we find reflected in the Markovic and Italy case I took you to, which is not jurisdiction, how can you give something you never had, as a species of reasoning, but rather that this, that is foreign act of state, exists as a court-created principled constraint, per Lord Wilberforce in Butts, on access to court in this way, and therefore does not, on any view, fall foul of the principled underpinning for this distinction that Lord Hoffman identified, and is therefore much closer in nature to the sort of doctrine that the court was considering in Markovic in Italy, and much closer in nature to that line of cases that Z and the United Kingdom and all those follow-ups, once they'd realised the errors of their ways into which I'd led them in Osman. So that's the first short point. Second short point, justification. No real attempt by my learned friend, Miss Kaufmann, to answer the short point that we made in opening in relation to justification of foreign act of state. The point on state immunity being clear and obvious as a result of the Al-Adzani decision, but in relation to foreign act of state, no real answer to the point we made in opening, which is that if we are right on the scope and reach of foreign act of state and that it should apply here, the engine of the Court of Appeal in Belhaj's reasoning in 1, 2, 3 starts working for us. And there was no real answer to that, to that point.
Which was it? Paragraph 1, 2, 3?
1, 2, 3, I think I had.
1, 2, 3.
Is it?
Works for us, yeah.
Can I very briefly deal with some points raised in relation to international law? And the first, and I mean, the reason we're in this territory is because it is said, I think, that if the court were to accept our conception of the doctrine of foreign act of state, that would necessarily place the United Kingdom in these cases in breach of international law. And my positive submission in relation to that, I make two submissions, one positive, one negative, not unlawful anyway, but the positive submission is, on the contrary, as the courts have acknowledged, foreign act of state is at least a reflection of international law. It may not be, per Lord Wilberforce's analysis correct of that paragraph in Sabatino, required by international law, but it is a proper reflection of it. And that is because it is closely linked to state immunity, and it shares, as the Court of Appeal in Belhaj correctly identified at 48, common rationale. And I took you to Lord Millett in Pinochet, quoted at para 53 of UKOS, pretty much on the same point. So we respectfully submit that not merely is it founded directly in international law in that way, but that it also reflects, and it is an echo point rather than a direct point, but it also reflects the position on the international adjudicative plane, see East Timor and Larson and all those cases. But secondly, it wouldn't place us in breach anyway. And so far as this is concerned, there is one initial point that needs to be made. Normally, what happens in relation to this sort of argument is that the person deploying it turns up and says, we have an absolutely clear position as a matter of international law. We can point you to it. There's an authority that says, here it is, absolutely clear, and as a result of that, you should develop or not develop the common law in a particular direction. It's trite that you can rely upon international law for the purpose of shaping or developing the common law. We don't seek to dispute that proposition. But normally you need to point to clarity, real clarity at the international legal level before that point works. And what we don't have here, as my learned friend Mr. Phillips reminded you in his reply submissions, what we don't have here in either case is any attempt, as it were, to plead directly today international legal causes of action. So this is simply being relied upon as a point designed, this whole international argument is designed to persuade you that you shouldn't accept our conception, and indeed the Court of Appeal's conception, of foreign act of state. And my respectful submission is that at its very lowest, international law in relevant respects is not clear, and the propositions that have been advanced before you on the other side, and to some extent by the interveners, are thoroughly controversial. And that raises a spectre of, in effect, the court being dragged into thoroughly controversial rulings on the nature, scope and extent of principles of international law for the purpose of buttressing an argument that the common law shouldn't develop the principle that we espouse. And that, we respectfully submit, is not a sensible or appropriate form of reasoning. So far as that is concerned, my learned friend Miss Lever took you this morning to the Convention Against Torture. We've dealt with that in considerable detail in our response. And I don't want to add very much to that. You'll find everything we really want to say in that response. But ultimately, it appears to come down, this question, to the nature and effect of Article 1 of UNCAT, read with Article 4 and the subsequent provisions. And we respectfully submit that what the true analysis, as we've set out in our response, is that Article 1 operates as a definition section, and that the true and negative rules that then follow are contained in the remaining articles of that convention, including specifically in Article 4. And Article 4 does distinguish directly between, on the one hand, complicity, and on the other hand, participation. So when and if you resolve that issue, if you were to resolve it in our favour, all our other points effectively drop away. Because if we're right about that basic and fundamental distinction, that you can't take from Article 1 something which is, as it were, less than complicity from the definitional section, and that distinction exists through the convention, then all her points about Article 47 drop away. All our points about Article 16 of the ILC articles become live, because you have to find somewhere else an indication of how a state can be liable as being complicit in the torture by another state. And once you get into Article 16 territory, the 2 points that arise are, firstly, that the pleaded allegations come nowhere near actual knowledge of the kind that would be required, but secondly, and in any event, Article 16 and its true reach and scope, it appears from even the submissions before you, is a matter of thoroughgoing international legal controversy, into which it might be thought the court, like the angels, might fear to tread. But so that's effectively what we say in answer to my learned friend's submission on Article 1. We've also pointed out in the response document that there is at least, again, some international controversy as to the question whether or not, I mean, it may or may not matter ultimately, but the question whether or not arbitrary detention and matters of that kind are in truth jus cogens. And we would invite you to note, in relation to the document handed up this morning, the extract from Brownlee, that the relevant part of that is dealing, in fact, with prescriptive jurisdiction over crimes. So the question is how that really advances the propositions here. What's this from? Oh yes, I'm reminded. Can I just invite you to make a note on that, also in a commentary by Professor Crawford, just to give you a reference. This is listing the various peremptory norms of international law. It's tab 232 in volume 29. The relevant extract or the relevant part is on page 11,392, and we would invite you to sideline paragraph 5 on that page, listing peremptory norms which don't include this part of it. That, I think, then leaves the idea that unless these claims are allowed to advance, I think it's advanced principally by the respondents in their cases and Ms. Kaufmann, unless these claims are allowed to advance, there will be a problem with the international legal rules governing remedy. And again, we've made a series of detailed provisions in our case, in our response. in relation to Article 14 of UNCAT in particular, and the question whether or not UNCAT requires a rule of universal jurisdiction. I want to go back to all of that. I think the respondents still maintain that it does, but have acknowledged entirely fairly that in order to persuade my lords and my lady of that proposition, they'd have to invite you to overrule Jones. So that doesn't seem a terribly attractive course of action, and I don't need to spend more time on that. But my learned friend this morning, Miss Leven this morning, sought to place it on the wholly traditional ground, as she asserted, of a jurisdiction over your own nationals. Well, the jurisdiction over your own nationals point only works if she is right on her basic conception of Article 1 and Article 4 of UNCAT. So it only works if you can say they were effectively the primary actors for this purpose, so as to require a remedy on that basis. My lords and my lady, that's all I wanted to say in relation to Article 14 and remedies. There was some, perhaps just by way of completeness, there was some reference to Article 13 of the ECHR as a standard, but as you're well aware, that's not incorporated in the Human Rights Act, not of general application, and in any event, no one's shutting them out from running HRA claims. That's the reason Article 13 isn't incorporated. My lords, my ladies, those, unless I can seek to assist further, are my submissions in reply, at which point I will close the file and be able to say to my lords and my lady, we've done our, no doubt, inadequate best. It's now your problem.
Thank you very much indeed. Well, we all thought it was a very good best from all of you. Thank you very much indeed. We're very grateful for your argument and for the fact you've managed to be reasonably concise in what is a wide-ranging set of arguments. Thank you very much for that. Avoided repetition and made your points very clearly. We're also grateful to everyone involved in preparing the written cases, which we found very helpful in advance. Thank you for that. We will consider our decision and let you know in due course. Thank you very much indeed. Court is now adjourned.